Nersa says it will appeal a court order to reverse a 9.4% tariff increase, which the court said was unlawful and correct procedures weren't followed. A Nersa subcommittee will recommend that a court judgment ordering it to reverse a tariff increase of 2 years ago be challenged. The subcommittee met to discuss whether or not the regulator should appeal the discussion of the North Gauteng High Court. The court last week Tuesday set aside a decision by Nersa in terms of Eskom regulatory clearing account application for the first year of the third multi-year price determination period 2013-2014 in that financial year. Nersa says it was the electricity subcommittee's view that the judge considered points that were irrelevant when making the judgment. Chris Yeland, energy expert, joins us now live on the phone. Can you please give us some more information on what this entails for the public?
Well, I think it's still too early to say. What we've had today is simply a recommendation by the electricity subcommittee of Nersa to recommend to the Nersa board that the judgment should be appealed. Tomorrow there's a meeting of the board, and the board will decide whether they are going to accept that recommendation or not. But I confidently expect that the recommendation of the electricity subcommittee of Nersa will be accepted and that Nersa will proceed to appeal the decision. And I believe that this will be followed closely by Eskom also appealing the decision. So in the short term for the consumer, it means that nothing has changed. The existing price increase that took place on the 1st of April 2016 will continue. Nersa and Eskom are likely to challenge this at the Supreme Court of Appeal. These things take a long time. It could be a year or more before such a case is heard at the Supreme Court of Appeal. And I confidently expect that if the Supreme Court of Appeal supports the judgment and opposes Nersa and Eskom, that Nersa and Eskom will take this all the way to the Constitutional Court, which could be another year or so's delay. So the status quo, as it stands at the moment, is likely to remain for several years whilst the matter is resolved in the courts.
Okay, and what would Eskom and Nersa have to do if this is appealed in the courts?
The next step, once Nersa's board decide that they will appeal, is they will have to, no doubt, make application for leave to appeal to the High Court. If the High Court grants leave to appeal, they will then have to submit court papers in the form of applications and documents and affidavits to the Supreme Court of Appeal. The respondents in this particular case, which is a number of companies in the Port Elizabeth area, will then respond. And there's a whole legal process, completely standard, that follows in such appeals. It's a long and drawn-out process, and it just means that the status quo remains until the matter is resolved, firstly at the Supreme Court of Appeal, and then possibly, if Eskom takes it on further appeal, to the Constitutional Court. That will follow. So all I can say is that at the moment one can really expect that the status quo will simply remain for a couple of years to come.
Thank you so much to Chris Yeland joining us there and emphasizing on the fact that it will be a very lengthy process before this whole situation gets sorted.